All right, everybody, welcome to another Law and Power case brief. Today we're going to be going over Spectrum Sports v. McQuillan. Quick disclosure, this is not legal advice. Okay, to the case brief. So this is a decision by the Supreme Court. It was held in 1993. It was unanimous, a 9-0 opinion. It resulted in a victory for the defendant. And the result was that the circuit court, in this case, the Ninth Circuit Court of Appeals, was reversed and remanded. The conduct at issue was attempted monopolization. The industries involved are medical products, sporting goods, equestrian products, and the statute at issue is Section 2 of the Sherman Act, which covers monopolization, attempted monopolization, and conspiracies to monopolize. Okay, the essential facts. So you had this company, Spectrum Sports, and the McQuillans. They were distributors of a product, this plastic polymer called sorbethane, the rights to which are owned by this company, BTR. Now, in the full facts, if you read the full opinion, BTR has a bunch of subsidiaries, and those subsidiaries have the various rights to make to distribute sorbethane. For sakes of simplicity, we're just gonna call all these companies BTR. It's just much simpler, and taking this factual shortcut, if you will, doesn't actually affect your understanding of the case at all. So we're just going to call them BTR. So BTR switched its distribution model from 5 regional companies to 1 national distributor. The McQuillans were eventually selected, but in order to actually be able to be the distributor, BTR wanted the McQuillans to divest their athletic shoe distributorship. They didn't want them to apparently sell athletic shoes anymore. The McQuillans refused, and BTR then subsequently refused to sell sorbethane to the McQuillans. The McQuillans' business subsequently failed, and then Spectrum Sports became the national distributor for sorbethane, and the McQuillans sued. So, in a lot of cases, it would just end there for the essential facts, but here it actually matters what the Ninth Circuit did, because the analysis that the Ninth Circuit did is really the main issue that the Supreme Court tackles here. So, what did the Ninth Circuit do? Well, the Ninth Circuit affirmed a jury verdict and found that because the verdict didn't actually specify the kind of violation, usually on the jury form they list like if this and this are found, then it's this violation, like it's a monopolization claim. If this and this, it will actually list it, but in here, that wasn't the case. So the Ninth Circuit basically picked that an attempted monopolization claim was established. And, each of the relevant circuits have their own analyses, if you will, of how to actually find whether conduct actually occurred. And attempted monopolization is one of those claims under the antitrust laws that has been a little wonky, or at least was before this decision, in terms of like the precise analysis. So what was interesting, and the full case, the opinion mentions this, is that the Ninth Circuit really was the lone wolf, if you will. They had sort of the easiest test for an attempted monopolization claim to actually be found. And so what was the Ninth Circuit's analysis? Well, they allowed the jury to infer that a defendant had specific intent, i.e. they wanted to commit the harm that ultimately resulted, and also infer that there was this jargon phrase, dangerous probability of success of monopolization, which is basically saying that there's a very high likelihood that what a firm wants to do, i.e. the specific intent, will actually happen. And they allowed the jury to infer both of those variables because, in quote, I'm quoting now, there was sufficient evidence from which the jury could conclude that the defendants engaged in unfair or predatory conduct. Now, again, you think of how powerful that is. If you could just identify the conduct, in which case, like, let's say a party says, they did this act to me and it caused me X harm, right? And if you could just infer, oh, that means because the harm was done, that means they wanted to accomplish this harm that occurred to me, and there was a high likelihood of success. That's a very low burden for a plaintiff, and so it makes sense here, at least, given the composition of the court, especially at the time and now, why they would want to be interested in a case like this, because it almost seems too easy. So what's the actual legal question at issue here? Is that, well, it's simple. What is the analysis for an attempted monopolization claim under Section 2 of the Sherman Act? This is the case that says, okay, we're going to clean up the circuits, if you will. Ninth Circuit is all on its own. The rest of the circuits have their own analysis. Let's just unify the entire analysis for all the circuits in the country. And the answer is actually kind of simple. It's an opinion written by Justice White. And there's really three variables that a plaintiff, in quotes, must prove. And it's a three-step process. The defendant engaged in unfair, predatory, or anti-competitive conduct. They have a specific intent to monopolize, which is a fancy way of saying they wanted to accomplish the kind of harm that they that is the basis of a complaint, and that there's a dangerous probability of achieving the monopoly power, that there's a high likelihood of success that it's going to happen as a result of the conduct. The rationale is actually quite simple here, is that the Supreme Court really based its decision based off of stringing together a lot of phrases from previous cases. I didn't include the whole quote here, but it's a long quote from this case, Swift Co. v. United States. It's an old case from the early 1900s. And there, Justice Holmes uses the, quote, dangerous probability. And so the court pulls in that and saying, okay, there's the variable we've been looking for. It's been there the whole time. It's sort of like the Supreme Court is basically saying that, look, you just had to read the text of these opinions, and you would have known the analysis all along. But here we are telling you anyway. So the court looks to the Swift case, which was really the first decision where the Supreme Court talks about attempted monopolization, and again, in there they talk about this dangerous probability. Then the court actually has a very interesting paragraph on talking about not just the previous case law, but also the text of the Sherman Act. Then it goes into a little bit of mentions the legislative history. It calls it sparse. I would disagree with that, but and they string this all together. They also cite a case called Walker Process, another case called Copper Weld. And by putting these quotes together, they come up with the analysis that a plaintiff needs to discuss a dangerous probability of success. They need to do that, they need to define a relevant market. What is a relevant market? It's the market at issue. What are we talking about? You can't be a monopoly of a specific product if that product isn't in a specific market. What market are you talking about? So you have to do that when you're trying to find a dangerous probability of success. You have to define the relevant market, which again is its whole long process. And then, of course, as part of defining a relevant market, you need to define a firm's quote unquote market power, which is in general terms the ability to affect prices or modify output of a specific service or good. So that's what plaintiffs are required to do to have a attempted monopolization claim. So again, the court, after now cleaning up the analysis of what actually is required for a attempted monopolization claim, the court remanded saying, okay, take these instructions, take what we've said here, and now apply it to the facts that you've been given. And that's the decision. As always, you can find a copy of this presentation at this link. All of the case briefs are listed on my website, casebriefs.lawandpower.net. The video link will be which is what you're watching, but I'm going to include that here after I amend, once I fully upload it. You can view all the case briefs and the main essential data on this website. It's an Airtable database, and feel free to subscribe to my newsletter. You can follow me on all these different platforms, X, Blue Sky, Mastodon, at Daniel A. Hanley. All my other links can be found in the link tree. And please subscribe, share, and like this video. It helps a lot. Thank you so much.